Number 64, People versus Jose Rivera.
Good afternoon, Your Honors. May it please the Court, Guy Talia from the Monroe County Public Defender's Office on behalf of Appellant Jose Rivera. I would like to reserve 3 minutes for rebuttal, if I may, Your Honor.
I'm sorry, did you say 2 or 3?
3 minutes, Your
3,
Honor.
yes.
Thank you. The primary relief we're seeking on this appeal is remittal to the sentencing court to properly consider the existence of mitigating circumstances in the commission of the offense.
With respect to youthful offender adjudications, doesn't the defense have the obligation to bring to the attention of the court that which they want the court to consider as a mitigating circumstance in the first instance?
Yes, I would say that's correct. The trial
And was
attorney-
that done here?
The trial attorney did not ask the court to consider self-defense in particular as a mitigating circumstance. It did note that the standard that for eligibility and then moved on implicitly saying that he should consider eligibility and then moved on to the factors for YO consideration. But the trial attorney here did not specifically ask the sentencing court to consider what we're asking should be done as self-defense as a mitigating factor. That's true, Your Honor.
So you concede it's not preserved?
That issue is not preserved. I think it does fall into the category of it didn't arise until Bruin came about. Traditionally, one would not think of the display of a weapon and loading a round into the chamber as a mitigating circumstance. But after Bruin, I think it's clear that
But with respect to youthful offender adjudications, it's a special category, and the courts do have the ability to consider the manner in which the weapon was being used, regardless of Bruin's existence, for the adjudication of youthful offender status.
yes, they do. The court in this instance, and I think an issue of law is presented because the court in this instance did not exercise its discretion to consider mitigating circumstances at all.
Is that because it didn't specifically say what it did or did not accept?
Well, I think it's a little bit more than it didn't specifically say. He actually went further, the trial court actually went further and conflated, first of all, the factors to be considered. It found that, the factors are, if you're not the sole participant, was your participation minimal? He said, no, I don't find the participation minimal, even though there was another participant. And then he kind of just concluded, therefore, there's no mitigating circumstance. And then the second conflation he made was the circumstances to consider for eligibility versus the mitigating circumstances with respect to YO adjudication. He said, I find no mitigating circumstances that would require me to find YO adjudication. But he didn't make the determination on mitigating circumstances.
I might agree with you that the trial court was inarticulate and perhaps considered some things before others, but I think the record is pretty clear that he did consider mitigating circumstances, that the totality of it is that there was a discussion there. It wasn't just the fact that it was an armed felony. I'd agree that it was an inarticulate way to approach it, but I think he hit the factors that he needed to hit to make the assessment. Am I wrong about that? And especially when he referenced the pre-sentencing report, do I have that wrong?
We disagree that the record reflects that he properly considered mitigating circumstances. Again, he said that he reviewed certain things. He didn't have an updated PSI. And then he said that there were mitigating circumstances. There's no mitigating circumstances requiring YO adjudication. That's a whole different set of circumstances that could apply to that, which he couldn't have considered because he didn't get an updated PSI. I think Rudolph required him to get an updated PSI to consider YO adjudication. So he didn't make the correct analysis. And then later, when he did try to consider mitigating circumstances, as you pointed out, he said, oh, and by the way, he double counted. He said there could be no mitigating circumstances here because it was an armed felony.
Well, I think he said exactly that, as such, there are aggravating factors as opposed to mitigating factors in light of defendant's participation. So that reference to defendant's participation is not reasoning only because it's an armed felon. So I think there was consideration. Like I said, I think it might have been inarticulate, but I don't think we can say there was no consideration.
Again, Your Honor, I think we disagree. Just based upon the fact, I mean, you mentioned that participation. Again, that there's two separate factors. Is your participation minimal? If he finds that if it's not minimal, he can't just necessarily then conclude there's no mitigating circumstances. He has to also look at, okay, your participation wasn't minimal, but are there also mitigating circumstances in the commission of this offense that could have also, it's two-pronged inquiry.
Right,
So
and what if
that's
the
it.
appellate division applied the correct analysis? Is that okay?
No, it's not. And the appellate division in this case actually did attempt to apply the correct analysis. I think they recognized that it hadn't been done below, but that is not okay because my client is entitled to a determination, and then he's entitled to a reviewable determination. So the appellate
But
division.
can't the appellate division, as it was done in ZH, in the Fourth Department, make that determination itself that YO should apply? Even when the court below did not?
Well, Your Honor, I think that deprives my client of his right to an appeal as a right. He has to have at least one review of the decision, and maybe they can do it in
But
the
you
favor.
do agree that the appellate division does have interest of justice jurisdiction to allow it on its own to review the record and decide to grant?
I think granting is different than denial, because if they grant, then the issue about my client's appeal of his right is moot, because they would have granted it. So I think there's a distinction.
If there's a record establishing what the mitigating factors are that the defense put forth, which they could have, the manner in which the gun was being utilized or not, that could have been put before the court.
It could have, sure, Your Honor. I think if there's a concern there, I think if there's a concern about that issue being raised, this court, obviously can find that the trial court did not properly consider. It can also determine that self-defense should be considered as a mitigating circumstances, and then remit it to the trial court, and maybe hold a hearing on, whether there was self-defense, and then do it in the first
So to the
instance.
extent that Bruin has any application here, you'd have to conclude that minors have a Second Amendment right. What do we know about that?
That is not exactly correct, Your Honor. So
Okay.
my client's age is irrelevant for different reasons depending on the argument that it's applied to. It's relevant in terms of considering mitigating circumstances, because obviously whether a weapon is used in self-defense is not age contingent. Someone could use a weapon in self-defense regardless of what age they are. Furthermore, in considering mitigating circumstances, we're talking about youthful offender adjudication. The whole purpose of that is to recognize that age is in itself is a mitigating factor, and to use it against him in that context would just be contrary
No,
to
that's
the whole-
fine, but what does Bruin have to do with anything you just said?
Bruin applies minimally to our first argument. Bruin is much more important in our alternative argument, which seeks remittal to the trial court with the presumptive ineligibility completely removed from the picture based upon the
But
unconstitutional.
that's my question, then. Is it presumptively lawful for a 5-year-old to own a handgun under the Second Amendment?
I don't want to get into drawing lines. I would guess probably not presumptively lawful for a 5-year-old. I mean, 17 is close to the range, particularly after Bruin. A lot of courts have nullified 18, 20-year-old prohibitions, or at least
sorry,
a couple
so-
courts have done that.
Can you just clarify, maybe I missed it, what would be the rationale for removing the presumptive ineligibility, in this case, that he's old enough?
No. The basis for removing the presumptive eligibility is because it amounts to an impermissible restriction on the newly articulated right to carry a firearm outside your
So
home.
you would challenge the constitutionality of the age restriction as well?
I don't think I need to challenge the constitutionality of the age restriction, Your Honor, because his age comes into factor for two reasons in the constitutional misclassification argument. One is whether he has standing, and because you could say, well, he was ineligible because he was 17. What difference does it make whether the statute differentiates between eligibility or noncompliance? But he clearly has standing. As the Chief Judge said earlier, standing amounts to an injury, and what he got was a lifetime ban on exercising his Second Amendment right. So his Second Amendment right has clearly been impacted by the classification, because it goes on forever, his whole life. The other context, his age comes up in the constitutional argument. Why it's irrelevant is because it's a facial challenge. So it doesn't matter whether he was eligible or ineligible for a license. The classification of the statute in all instances as a violent C felony is a facial problem, because there's no circumstances where it would be proper to classify someone as a violent felon for any unlicensed possession. And that kind of I have to backtrack a little bit to explain that in full. So,
But does that have anything to do with Bruin necessarily?
yes. Bruin, prior to Bruin, the state was fairly free to regulate public possession. It could, restrict it with regulations, with licensing, because there was no extension of the constitutional right, fundamental right to do that before Bruin. And Bruin also said that now you have this general right that's subject to very restricted limitations. So it did allow licensing, we acknowledge that, but there's basically two reasons you can be unlicensed. One, because you're ineligible, or two, because you didn't comply with the statute. You're eligible and you just didn't go and seek a license. And right now, New York penalizes either of those circumstances as a violent felony. And under Bruin, the purpose of licensing under Bruin is to ensure that those who are disqualified from exercising their right are not carrying. It doesn't contemplate licensing as creating a whole new class of people who are now permanently disqualified from exercising their Second Amendment right, i.e. unlicensed people. So to treat someone who is just merely non-compliant with the law and permanently disqualifying them from ever exercising their Second Amendment right is unconstitutional under Bruin, because it amounts to an impermissible restriction
But
on the right.
I may have misunderstood what you're saying here at the end. Bruin is striking down a part of a licensing scheme, part of New York's licensing scheme, not the entire licensing scheme. So it's
Yes.
recognizing that New York and other jurisdictions can regulate, can have a licensing scheme. So I'm sorry, I'm not understanding this last part of your argument.
Sure, no problem. Our argument does not hinge on striking down the proper cause requirement.
Okay.
It's not. Our argument is based upon the foundational holdings of Bruin to get to striking down the proper cause requirement. Number one, extending Second Amendment protections to outside the home possession. And number two, saying that you can't place restrictions on that right, that newly articulated right, unless it comports with the nation's tradition of firearm regulation. So what it boils down to is there's no tradition in our firearm regulations saying that noncompliance with a licensing thing permanently disqualifies you from ever exercising your Second Amendment right again. And
Is there a history of regulating underage people? Like the chief judge referred earlier, a 5-year-old. So you're saying the state can't say that age is a consideration as to whether they are capable of exercising that right in a manner that is not dangerous? You're saying Bruin took all of that away, and anybody at any time, no matter who you are, whatever age you are, you can have a gun.
no, we don't. That's not what we're saying. We don't think that that's what Bruin said. Like again,
So clearly, what are you saying?
So again, we're saying that to classify as a violent felony all unlicensed possession, whether it results from noncompliance or because you're ineligible, is an impermissible restriction because it permanently
So the
disqualifies you.
statutory classification in the manner that it does is what you're contesting.
Yes, I think
What
that's
you-
correct, Your Honor. Yeah.
If I'm understanding this last piece, what you're really contesting is you can't impose a lifetime ban.
Right, you can't impose a lifetime ban for noncompliance. In fact, New York already has a statute that punishes noncompliance. It's in the licensing law, it's 400-0015, and it says that noncompliance with this licensing regime is an A misdemeanor.
Is that because at some point it assumes you're going to seek a license?
Well, I think that's put in place because without that, a licensing regime is more a suggestion, right? You have to have some manner of punishing a failure to comply with a licensing scheme, but
Do you know of cases where somebody who was possessing let me try it this way. Do you know of cases in which somebody who had a license to possess a gun, let's say in the home, was found with a gun on the street and was prosecuted under 415?
no, Your Honor, I'm not aware of any prosecutions under 415.
At all?
In my experience, no.
Okay,
I've never
that's
seen
what,
that.
I didn't find any either.
Right.
Okay.
Which they're all prosecuted under 265-033, and that's.
And so 415 is very, very brief, and it really just says any violation of any provision of 400.00 is a misdemeanor. And 400.00 includes things like the police will conduct a thorough check, and they have deadlines. I mean, it can't possibly be that everything in there is a misdemeanor if you don't do it, because everybody who's involved in any kind of gun licensing is guilty of a misdemeanor.
It is very broad, Your Honor. It just talks about non-compliance, and
But you found nothing.
we found nothing on that. Yes, that's correct, Your Honor. So that's how Bruin comes into play. So we have the first argument: consider mitigating circumstances, remit to consider whether self-defense should be a mitigating circumstance, which my client would then be eligible for YL consideration. The alternative argument is that the classification of all unlicensed possession of C-violent felonies is unconstitutional, and therefore should be remitted to have my client considered eligible for YL consideration, to be considered there. I see my time has expired. I don't know if the court wants to get into preservation issues or anything like that, or otherwise I'll
Thank you. You can get to an
reserve my
rebuttal
time.
if you need to. Thank you.
Thank you, Your Honors.
May it please the court, good afternoon, Your Honors. Lisa Gray on behalf of the people. With respect to appellant's request for remittal to consider self-defense in terms of the youthful offender adjudication, whether or not that it created a mitigating circumstance, the people would certainly oppose remittal. Judge Singas, to your point, the sentencing court could have been a little bit more articulate, but the record is clear that, the sentencing court took into consideration its obligation, what factors it needed to consider, and it laid out everything that it did consider when it came to deciding whether or not Mr. Rivera could overcome this presumptive ineligibility in order to even get to the question of youthful offender adjudication. The sentencing court said, listen, I looked at the plea minutes. I don't know that the court said necessarily plea minutes, but the court said I looked at the entire record. I looked at all the prior proceedings. And in the plea minutes, Mr. Rivera did raise an issue about, the reason why he had that loaded gun. So, even the court was certainly aware of the circumstances surrounding the possession of this loaded firearm. The court noted that, that it was Mr. Rivera.
Whose responsibility or burden is it to put mitigating circumstances before the court?
It was certainly Mr. Rivera's responsibility to do that, and he did not. But the court, even that
The court
failure
looked at
didn't
it
deter the
anyway.
court. Yeah, the court went through its analysis. And I just want to note that for this particular sentencing court, he actually makes reference to a previous case that had been returned by the appellate division. So this particular court was acutely aware that it had actually made a mistake earlier with this exact same issue, and again, to your point, Judge Singas was very much aware that the court wanted to do it properly a second time, and it did so, based on all of the factors that, the defendant admitted he was not the sole participant. He admitted that he illegally possessed it. It was a stolen firearm, and that none of those factors militated against or militated in favor of overcoming that presumptive ineligibility in order to even get to the question of youthful offender adjudication.
So some part of his argument, of Mr. Rivera's argument, I thought, was that essentially the court might have looked on my eligibility differently if it had read Bruin, which it couldn't have read at the time, because I have, and put aside for a moment the fact that he's 17, I have a constitutional right that the court wouldn't have recognized, and that's a mitigating factor of a sort. What do you say to that?
I think that this court needs to reject that, and I'll tell you why. Because I think it's really important for this court to remember what question the Supreme Court actually did answer. They were asked to answer a broader question, and the Supreme Court said, no, we're going to narrow this, and we're going to only address this proper cause requirement, whether or not ordinary law-abiding citizens have to show some additional reason for self-protection purposes in order to get this public carry permit. They were asked a broader question, they narrowed it. And by doing that, that did not create any sort of sea change in the way that New York has the ability to enforce unlicensed gun possession. Now, going to Mr. Rivera's argument that, at 17, barely 17, he had just turned 17 4 months before this incident had occurred. He would not have been eligible for a pistol permit. He had no, he didn't preserve the argument. He has no standing. And the decision in Bruin, again, addressed only a very narrow issue, and it doesn't apply to the criminal possession of a weapon statutes here in New York, and it's certainly, Mr. Rivera can't avail himself of the holding in Bruin. I mean, getting to preservation, and obviously this court discussed this at length for the previous case, but even if, Mr. Rivera could have raised this, certainly he didn't raise it at the trial level, he could have raised it at the appellate level, and his lead application to this particular court was pending when the Bruin decision came out. And it wasn't until this court affirmatively sought the parties' opinion and input on whether or not Bruin applied to this case. So again, even while his leave to this court was pending, he did not seek to amend or supplement his leave application in order to incorporate any of these Bruin arguments. They're certainly not preserved. With respect to, standing, again, Mr. Rivera was 17. He was not even eligible for a pistol permit. And to the extent, to the extent he's even raising a claim as to the age restrictions on licensing statutes in New York, which he's not.
Well, he does say the conviction results, right?
He
Doesn't
does.
have why the conviction results in this ban, and that's a violation of Second Amendment rights. That's what he's saying.
Yes, he does say that.
What's your
But
response to that?
My response to that is Bruin only dealt with a very narrow issue that applied to the licensing scheme as set forth in 400. And it left intact all of the criminal possession of weapon statutes here in New York and New York State's ability to legislate the punishment and the sentencing as it relates to the convictions. So Bruin is separate, the holding of Bruin is separate and apart and does not apply to the sentencing challenges that Mr. Rivera is raising.
Would that include a defendant who it was obvious from the record? I'm not talking about this defendant, hypothetically. A defendant was obvious from the record. The only reason he would not have gotten that license is because of the probable cause requirement.
Just repeat that one more time, Judge.
Would your position be the same if it's a defendant for whom it is obvious from the record that the only reason that they would not have gotten a license is because of the probable cause requirement?
New York still retains the right to enforce the unlicensed possession of a weapon outside the home or place of business.
Yes,
And-
as long as the licensing provisions, as I understand Bruin, as long as any of those licensing provisions and requirements do not go afoul of the Second Amendment.
That individual still has to submit themselves to the licensing regime. They still have to apply for a license. And they cannot be denied a license, obviously, by showing some additional need for self-protection over and above just ordinary, the needs of ordinary self-protection.
But so your position is if everything in the licensing scheme was unconstitutional, every element of it violated either the Second Amendment or some other constitutional guarantee, somebody would still have to apply for a license and get rejected to be able to defend a prosecution?
Well, I think in order to attack the constitutionality of the statute, it must be on its face unconstitutional across the board in every manner. And in the CPW statute, it's unlawful possession of a firearm outside your home or place of business. And so there are many reasons why someone might not have a pistol permit in order to possess that license outside their home or place of business. They could be a previous felon. There are other classes that Bruin sort of carves out and uses an example of why licensing schemes are still necessary and are in effect across all different states. So the criminal statutes are not unconstitutional as they relate to Bruin, because there are other reasons why somebody might still be prosecuted because they are constitutionally barred from having a license. And in this case, Mr. Rivera is not making any sort of claim that the age restriction in 400 is unconstitutional. He was 17 at the time. He possessed that loaded stolen firearm. Bruin does not apply to his conviction, his sentencing. All of those things still remain intact, even in light of the decision in Bruin. It's the people's position that certainly remittal is not required for the judge to consider self-protection as put forth by Mr. Rivera in light of Bruin. And for those reasons, the people would ask that this court deny Mr. Rivera's request for remittal for any reason.
Let me just ask you one more thing.
Sure.
Are you aware of any prosecutions under 415?
I'm sorry, Your Honor, yes, I did mention it. I meant to acknowledge that question. I don't. I'm not aware of any, Your Honor. And I also can tell you that I'm not aware of any cases in which somebody has been prosecuted under CPW 2 having had a pistol permit. But I'm not aware of anyone being prosecuted under Penal Law 415.
I'm sorry, when you say a pistol permit, you mean a pistol permit that has a restriction in it? Where they're in violation of the restriction?
Correct, yes.
You're not aware of any prosecutions of that sort?
Right,
Okay.
yes.
Thank you.
Thank you.
Good afternoon.
Good afternoon.
May it please the court, Margaret Seepries on behalf of the Attorney General, who's intervening in this matter. This case, as has already been discussed by ADA Gray, does not present a question of law because defendant admittedly did not preserve this claim in the trial court. I just want to add a couple of points to what ADA Gray had said that. With respect to the argument that there were no grounds to raise this prior to Bruin, I just want to point out in People v. Hughes, which has already been discussed in 2013, this court said that it was an open question regarding whether or not the Second Amendment limits penalties for unlawful gun possession. So it was an open question, and this defendant certainly could have raised this in 2017 when he was resentenced. In addition, Bruin extending the right, the Second Amendment right to public carry outside of the home did not come out of nowhere. There were certainly indications in the Supreme Court's language in Heller that, although in that particular case it only involved in the home possession, that the court was discussing both keeping and bearing arms as being protected within the Second Amendment. So it was not something that you needed to be a soothsayer in order to know that this is where this was going to be heading.
Does Mr. Rivera have a Second Amendment right at all?
He does not have a Second Amendment right, Your Honor. Mr. Rivera had he was not engaged in any constitutionally protected conduct. He had no right to carry a license. He wouldn't have been eligible for 4 years to carry that license, something that he, again, does not challenge here. And he was engaged in conduct that is not protected
Yeah, I
by
didn't
the
really
Second.
mean, right, I didn't really mean statutorily, I meant constitutionally. Does a 17-year-old have a Second Amendment right?
No, Your Honor, there's nothing that entitles a 17-year-old under the Constitution to carry a weapon. And he's not, as I said, he's not challenging that here, and he didn't raise that below, and there has been no litigation on whether or not, as a 17-year-old who was, almost 18, whether or not he should have had that right. So that's not an issue. But just one more point on preservation. There would have been sound reasons in this case to require the preservation. Well, for one thing, two reasons. A practical reason, if the efficiency of the process would have been enhanced in this case if he had preserved his claim in the trial court. This would have given, this was a negotiated plea involving 2 different indictments. Had he raised his constitutional challenge at that time, and they still wished to negotiate a plea, the ADA could have offered a plea that might not have been potentially subject to challenge on appeal. So just in terms of an interest in ensuring the efficiency of the litigation, if he had raised it, that would have gone out of it. And the other reason is there are sound reasons to support the requirement of preservation. In this particular case, defendant is asking for systemic changes in the penal law and in CPL. And he's asking for very drastic steps that this court should not be addressing in the first instance without litigation below, without opportunity for the parties to have raised these issues, aired all of their arguments, and for both the trial court to present a reasoned decision as well as the appellate division, so that when it gets to this court has a full record in order to consider this issue.
Let me go with the argument that he's not making the argument about the lifetime ban. Let's say he was. Can someone who is a minor challenge the lifetime ban, or only someone who is imposed the ban able to challenge that if they're an adult?
Well, our position is that he certainly doesn't have standing in this litigation, or an adult wouldn't have standing in this litigation until he actually, in the future, applies for a license and is turned down. So
Wouldn't that be obviously futile? Why would you apply when the court has ordered a lifetime ban?
Well, there's been no lifetime ban ordered. That he is not banned. There's no outright ban saying that he can't apply. He could apply and see if he...
And he might potentially be granted a license? Is that what you're saying? There's no obstacle to granting the license?
Well, his conviction certainly is an obstacle.
That's what I'm saying. Why
Yes.
is that not futile?
I'm sorry, why is that?
Would it not be futile? If the purpose of that is to file some papers, but you're never going to get granted the license.
Well,
because
our
it's
position
banned.
is, it's not that it's not,
You're an ineligible class.
right, but that's something that hasn't happened to him yet. He hasn't suffered that harm yet. He hasn't faced that yet. And that is not relevant to this particular litigation. Now, with respect to the merits, our position is that this is not a Second Amendment issue, and this is not an issue that was based upon Bruin. Defendant does not assert a cognizable Second Amendment claim because Nothing in the plain text of the Second Amendment, nothing in Bruin, limits penalties for unlawful conduct for violations of the Second Amendment. And nothing in the Second Amendment controls what conduct a state may criminalize. Well, the Second Amendment controls what conduct a state may regulate and what the state may criminalize, but it does not speak to what penalty the state may impose once there's been a violation. Now, so the defendant vastly overreads Bruin in arguing that the classifications of 265.033 violate the Second Amendment. Nothing in that decision casts any doubt on the laws that criminalize unlicensed carry or the sentences that may be imposed. These are legitimately policy-oriented issues that the state may make depending upon. There's nothing in the Constitution, nothing in the Second Amendment in particular, that requires the state to take into account the reason why the person who doesn't have the license failed to get his license. Nor does Bruin undermine the state's authority to treat unlicensed public carry differently from unlicensed possession in the home. Again, that's a
Would that hold true post-Bruin as well?
yes, because the striking down of the proper cause requirement did not mean that for sentencing purposes, the states must consider in-home carry and public carry equivalent for all purposes. Nothing in Bruin said that the states may not take into account the very legitimate concerns that might arise when somebody carries a gun outside, potentially at risk of harming many people, as opposed to when somebody has a gun in the home.
So the rationality and the difference of penalty survives post-Bruin?
Yes. And nothing in Bruin undermines that authority. With respect to the mitigating circumstances argument, again, nothing in the Second Amendment requires the legislature to treat someone who's under consideration for youth offender treatment, whether or not their conduct is protected by the Second Amendment or not. But the facts in the record in this case do not even support a self-defense claim, which I know has been touched on. But there was, under no circumstances, is there support in the record that this defendant used his gun in self-defense. The facts of the matter are that when this argument occurred, the defendant was in a car with another person, and that the people whose house he was parked in front of came out and were outside of the car, and that this verbal argument ensued. There's no indication that anyone that they were arguing with had a weapon. But under these circumstances, the defendant took the time to pop the trunk, get out of the car, and get a gun, which he brandished, and activated the slide chambering a bullet so that it was ready to go. And nothing in the record suggests that he had any reason to fear this situation, and that he had any reason to use that weapon as he did.
Thank you.
I'd just like briefly to address a couple of issues, Your Honors. First, on the merits, our argument here is, unlike the one in Hughes, is very concrete and tied directly to the Second Amendment. In Hughes, the connection was unclear. It was almost like a proportionality argument or a chill on Second Amendment rights. Here, the argument is based upon the foundational holdings of Bruin, as I said, extending Second Amendment protections to outside the home carry with limited restrictions. By classifying all unlicensed possession as a C felony, and then resulting in that lifetime ban, as they admitted that he can't get a license because he's now a violent felon under New York law, is an impermissible restriction. It's not contemplated by Bruin. It wouldn't be condoned by Bruin.
I'm sorry, how does that, I'm just maybe not understanding this, how does this apply, what your argument is here, to the YO determination? Because you could go apply for a license later with this felony and say, this is unconstitutional, you're denying me a license because, of Bruin. And you can litigate that if they deny you the license based on this particular conviction. But how does then this overlay the YO determination? It
Because
seems like what you're arguing is secondary effects of your conviction.
it's not secondary effects because his conviction, the fact that he was convicted of a violent C felony makes him presumptively ineligible for YO consideration. And because that classification we're arguing is unconstitutional, he wouldn't be presumptive, he should go back and not be presumptively ineligible anymore. So the highest level crime that he should have been guilty of was the A misdemeanor for either noncompliance or in-home possession.
Isn't another way to look at that, that after Bruin, he may no longer be presumptively ineligible? So you can litigate that.
He can litigate the issue later on in terms of, whether he may be qualified to get a license. He can argue it there, maybe a little bit too late at that point. I think that the time now is at sentencing, but he got a 10-year sentence where he could have gone for YO consideration if he had not been presumptively ineligible, and the maximum he could have gotten is a 4-year sentence if he qualifies. Now, that would be a later determination to be made, but if the violent felony made him presumptively ineligible, he should not have been, the classification of that in all circumstances is unconstitutional. It should have, we tie it to noncompliance in a misdemeanor or in-home possession in a misdemeanor. He would have gone right to the second stage and consideration of YO adjudication. And if he got YO adjudication, his sentence would have been drastically different than the one he received.
Thank you, counsel.
Thank you, Your Honors.